Okay, busuan for me chacho bi na me sa mo bibia kwaba. Mfambra ayeka TV. Busuan for Kim Kranchi um lawyer ni mapa o manga na mo ase busuan for. Odi application bi ekodan court na chese or chese John Dramani Mahama flagbearership of the NDC Emmanuel Kono or chese wabedi Ghana emra no so no wabro so se osa pese otena so biem president bi no file sa application we de kodan court ma court na application ni gui na ne nsɛm bi a na ɛwɔ mu no na kyerɛ sɛ ɛnneɛma 1 2 bi na kyerɛ sɛ ɛyɛ wrong na ɔpromise sɛ ɔbɛsa akɔ aba biem ama ɔsa de na court ɛbɔɔ na application no guiɛ no NDC foɔ mpanyinfoɔ no bebree na aba abɔnten ɛbɛdi ne ho fɛm kyerɛ sɛ ɛyɛ adeɛ a ɔpɛ sɛ ɔyɛ nyansa bi ɛne hɔ ɛwɔ abusuafoɔ me ne wo ka sɛ wasa file application foforɔ akɔrɛte ne mistakes bi a na ɛwɔ application no mu bi a asa de akɔdan court na abusuafoɔ me ne wo ka sɛ court atena saa asɛm no so sɛ John Dramani Mahama yɛbɛtumi disqualify no sɛ ɔntumi stande anaasɛ ɔntumi nyɛ flag bearership anaa ɔntumi stande for president ɔman Ghana mu ase bi gyebra ne nkuti nsɛm mu nkyɛn mu yɛkɔba yɛbɛtoa so mɛsɛ sɛ na ne day kan ɔtumi a mɛsɛ sɛ subscribe to my channel like na do adwenkyerɛ so go comment section kama.
The NDC, led by their lawyers, Edi Ibrahim Kranchi, and Hofel, can say what the ban predu Supreme Court, Ebebogum predu, San say, Adiana of Fale, Sebi, and Tasumo, Nyansani. Ibrahim Kranchi Sako back, Echo correct all the administrative errors, said your promise, assign and refile the case involving the disqualification of former President John Dramani Mahama from contesting the 2024 elections. Na ene the Supreme Court of the land etra asem so. Na nyame no kredi mini ene yewra ken kranche Supreme Court and dismiss case. Dem no Supreme Court kire mu a onkoye amendment in some of the reliefs in his action seeking to disqualify Mahama from contesting the 2024 elections. Reliefs being and a Supreme Court to come once. Now, among the reliefs, Mr. Ken Kranchi, or your private legal practitioner, is seeking a declaration that upon the true and proper interpretation of Article 66 Clause 1 of the 1992 Constitution, clearly stipulates the number of years of a presidential term to be 4 years. In court on Wednesday, May 8th, the plaintiff, Ken Kranchi, sought leave from the court to expand 2 of his reliefs by adding some constitutional provisions to them. His request this time round was not opposed by the respondent, that is the Attorney General, Godfred Yeboah-Dame, counsel for John Mahama, Tony Lito, and lawyer for the Speaker of Parliament, Thaddeus Sori. Today, the Supreme Court panel was chaired by Chief Justice Gertrude Tukono, with Justices Mariama Owusu, Avril Lovelace Johnson, Henrietta Mensah Bonsu, Samuel Asiedu, Ernest Gewu, and Yao Dakun Asare. Enti ene Supreme Court judges ya ekwa setena ya omo Emma Yewra Ken Kranchi kwan for amendment no na Chief Justice Gertrude Tukono, Justice Mariama Owusu, Justice Lovelace Johnson, Justice Henrietta Mensah Bonsu, Justice Samuel Asiedu, Justice Ernest Gewu, and Justice Yao Dakun Asare. Into 7 justices of the Supreme Court of the land. NNA Omokwaseta. Now, which the more Yewra Ken Kranchi amendment in the bill enyina ewia Yankopon ya domo May 10th 2024, which is on Friday on Famra the court. Now, Mr. Ken Kranche ono ankasa na representing ho and I to court say or person or expanded the first two of his main reliefs seeking to disqualify the former president John Dramani Mahama from contesting. Now reliefs or seeking to expand the one a declaration that on a true and proper interpretation of Articles 66 clause 1 and clause 2 of the 1992 Constitution. I say a person seeking a second presidential term must be a sitting president. A person seeking a second presidential term must be a sitting president. Declaration was signed expanded and so a declaration on the true and proper interpretation of Articles 66 clause 2 and 3 of the 1992 Constitution. And also say a second presidential term must be consecutive to the first term. A second presidential term must be consecutive to the first term. And when we and according to European country, all choir amendment assigned at the constitutional laws should be account. Now the plaintiff is asking the Apex Court for the following reliefs. 1. A declaration that on the true and proper interpretation of Article 66 clause 1 and clause 2 of the 1992 Constitution, a person seeking a second presidential term must be a sitting president. That is the number 1. Number 2, a second presidential term must be consecutive to the first term. Number 3, a former president of Ghana falls under the supervision and control of the Parliament of Ghana in all his or her future offices. And also Article 68 clause 2 of the 1992 Constitution. And also a former president of Ghana requires parliamentary approval before he can occupy any other office that provides a monument. And no Article 68 clause 2 and also true and proper interpretation. The office of president is an office that provides a monument. And no Article 68 clause 3 and also true and proper interpretation. A former president of Ghana remains in the employ of the state. And no also a true and proper interpretation. And no Article 68 clause 4, clause 5, clause 6, clause 7, clause 8 and clause 9. Mami en church the makani entoa eso. The kind say you can practice the court in church anymore. Because 1992 Constitution 66 Article 66 clause 1 and 2 say Obia or say Obeko second term as president no Constitution na state say e was say oye sitting president and sign over to me as a contest e dey run for a second term. But in the case of former president John Dramani Mahama odi the first term we yem when to me antoa so say oye former president enti Supreme Court in church anymore say akwanya ben na da ho no muntia eni former president John Dramani Mahama as a contested for the 2024 election. And I was uncle to be on say Article 66 clause 1 and 2 of the 1992 Constitution chiremwa. Second presidential term no it was a year consecutive to the first term. It was a 12 first term so. But in this case, former president John Dramani Mahama tried the first term we again. Ghana for two ni banchi in the first instance. And a Ghana for some boo ni faso in the second instance. Into what we mean. And I was saying baby into say Ghana for trouble manamana sa baby one. And ya consecutive. Because in fear pole won twe and ababe dantem. Into Supreme Court to change the move factor. Se samra no, se pa na se kireti. And I dey to so miensa say obi a former president. Now person occupy office fufuro biom than office of the state. Ohia say Ghana mrahye bedwa ebegiatum. And also your Article 68 clause 2 enti no saying opponent ase no etie. And a biom wɔsan kyerɛ mu sɛ obi yɛ former president a saa office no Ghana aban ɛsan ɛhwɛ no ɛma no monument ɛsɛ waba pension in the natural sense nti ɛno no sɛn ɛno no ohia nkyɛkyerɛmu from the Supreme Court because obi ɛkɔ pension ne etua ne pension pay a ɔno kenkranche nyinyi ntu sɛ ɔbɛsan aba into active office nti nkyɛkyerɛmu ɛna bio ɔkyerɛ mu a obi ɛyɛ former president a aban